From the WATE.com Digital Center, answering your legal questions, this is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi, everyone. Thank you so much for being with us today, and it's always good to see you.
Lori, it's great to see you.
All right, here's what we're talking about today. The U.S. Supreme Court nearing the end of its term. It's going over a lot of cases, 100 to 150. And there's some that stand out. Many of you have been weighing in on this one, and that is the Supreme Court has lifted a ban on bump stocks. Let's talk about what those are, and then we'll go into the fact, taking a deeper dive, that the Trump administration banned them after a deadly mass shooting, and now that ban has been lifted by the Supreme Court. So let's talk about what they are and why they figure so largely into what people are concerned about.
Right, we're here at the summer term of the Supreme Court, and it is the slowest term of court since 1946. 7,000 writs of certiorari, that's permission. People asking for the Supreme Court to hear their case. Only 100 to 150 are selected.
Yep.
And one of the marquee cases was the Garland case. And that's the constitutionality of the ban on bump stocks. And if you'll recall, during the Trump presidency, there was a mass shooting in Las Vegas at a concert. Horrible tragedy.
Oh, it killed nearly 60 people.
Yeah, it was just horrible. And so there was a ban on these bump stocks. And what they do, they make the gun fire more rapidly. And there's a fine line between whether it's semi-automatic or automatic.
But these apparently can fire between 400 and 800 bullets per minute.
Per minute. And what's interesting, so fast forward, a Texas gun dealer challenged the constitutionality of the law, and in a really unique opinion, Clarence Thomas was speaking for the majority. Instead of getting into the historical precedent that they went down in the Bruin case and analyzing that, he analyzed the mechanics of the bump stock and the difference between automatic and semi-automatic. And in a engineering-esque Supreme Court opinion, which we're talking about principles of constitutionality and freedom.
He's going down the line.
He's an engineer. He's a gunsmith. And what he concluded was that it simply enables one to pull the trigger quicker, and it's not automatic. Therefore, the ban is illegal. And so it was stricken.
The justices did not all agree on this. It had to be really contentious in there. And Justice Sotomayor came out and said, basically, this means more people are going to die.
Well, you know, and when you have a Second Amendment issue before the Supreme Court, it is watched by people all over the country, and you have lobbies, you have amicus briefs. And it was interesting because the Supreme Court, remember the Bruin decision, where they said to constitutionally regulate firearms, ban firearms, you have to look at the intent of the framers and place the legislation in the historical context. But
having said that, let me ask you this. I did some research and looked at some reaction to this. Okay, so you're talking about the framers of the Constitution. This person writes in, valid questions for the keepers of our Constitution might be, what does free access to tools of death have to do with a more perfect union, justice, or domestic tranquility?
Well, you know, it's there are, and what's interesting about this term, there is always spirited, heated debate on both sides of Second Amendment issues.
On this one.
But think about what the Supreme Court did. In the Garland decision, you know, they made a ruling that was incredibly pro-Second Amendment and created a lot of pushback. But in the same term, they upheld a state law that prohibited someone from possessing a firearm if you were convicted of a domestic crime of violence or a restraining order. And that decision
what does that say to you?
And that decision was 8-1. And Justice Kennedy in that one went back to the basics and talked about Bruin and the framers and this and that. So you had everybody, with the exception of one justice, ruling on the other side. So interestingly, In the Garland case, very controversial, where you struck down the Trump administration ban on bump stocks. Then they turn around a week later and uphold a ban on possessing firearms if you are have been convicted of a restraining order or crime of domestic violence.
Yeah, the big argument, like you said, just to underscore this for people who are watching it closely, they said it doesn't violate the Second Amendment, which of course is the right for people to keep and bear arms. But the domestic violence issue comes into play there. But then on this other one where they lifted this ban where 60 people died, and then there was the Parkland shooting, same situation. Do you find that surprising? Or are you looking again at the mechanics of Clarence Thomas boiling it down to a black and white issue?
Well, I think if you are someone that follows the justices and what they do, in the 8-1 Rahimi decision, and that's the one that upheld a ban if you're convicted of a domestic
Right.
crime of violence or restraining order.
Yeah, a restraining order against
the
you.
lone dissenter was Clarence Thomas, who was the one that authored the other opinion a few weeks. So
Okay.
I think what you're seeing is that Justice Thomas has drawn a hard and fast line in the sand, and is going to be very vigilant when it comes to any ban or regulation that touches on the Second Amendment.
Very interesting. Where are we headed when it comes to gun laws? What are you seeing from what you do for a living?
What I'm seeing is and I think the Bruin decision was very insightful when it talked about this historical intent of the framers. I think you're seeing there was a trend to try to have legislation, you're trying to do more regulation. You know, we had that here in Tennessee with Governor Lee called a special session out of the school shooting in Nashville. But I think what you're seeing is the courts are reluctant to regulate firearms in the Second Amendment. And I think it's been surprising because you have this very unique juxtaposition where you have an increase in violence, but yet a more rigid court that is very protective of the Second Amendment. So really interesting how those two dynamics have played out, because one would have thought the more gun violence, the more regulation, the more this,
Right.
that you would see some modification of the Second Amendment interpretation, but it's actually trending the other way.
That is so interesting. And when you think about the families of the victims who died, their outcry is getting louder and louder over this.
Well-
Does that have any sway over these decisions?
Well, you know, if
Or they just looking at the Constitution?
the job of the 9 justices is to interpret, safeguard the Constitution and
Yeah.
our fundamental rights. And you know, sometimes there are decisions that are very unpopular. Sometimes there are decisions that are very popular, but you know, they are tasked with seeing things in a vacuum. Now, that's interesting in the context of, and it doesn't matter if there's a liberal majority on a court or a conservative. Everybody says the court's been politicized, and who knows? We're all just people, and we all vote.
And they all did not agree.
And they all did not agree. But I think when you read the tea leaves, you can see where these justices are coming down.
Yeah.
But Clarence Thomas has entrenched himself as a very staunch protector and supporter of the Second Amendment.
Want to talk more about it at 5:30?
Let's do.
All right. Thanks for being with us. Oh, one thing before we let you go. Want to let you know that we won't be doing a live stream for a couple of weeks. We'll be back on July 17th.
On
But
July
we'll still have
17th?
our segments on the air. So be sure to look for our next live stream. It'll be quite the topic. We'll pick a great one. We'll pick an exciting one with lots of fireworks after the 4th of July.
Sounds good.